Hi, my name is Nathan Franson. I want to talk to you today about service animals and specifically how, as a landlord, you can avoid getting in a lot of trouble for not handling this properly when your tenants make these requests. So let's talk first about service animals because they're not the same as pets. And a pet, this is just a dog, cat, etc. that the tenant's going to use for their own enjoyment, versus a service animal, which is really an accommodation. It's something that is meant to treat a disability. And so we understand this when we think of seeing eye dogs, and we understand that a blind person can have a seeing eye dog and that that's a benefit to them. It's not always as obvious though, and so I want to make sure I explain to you as a landlord what your responsibilities are in that situation. With pets, you can charge a security deposit or a pet deposit, and this can be in addition to your ordinary security deposit, as long as you don't go over the limit, which is 2 months for a unfurnished house or unit, or 3 months for a furnished house or unit. This is in California, of course. So if you stay under that limit, you can call it whatever you want. Best practice is to just simply refer to the whole thing as a security deposit and not break it up. Just makes it easier when you do the reconciliation when the tenant moves. But for service animals, you cannot charge an extra deposit of any kind. You still can recover damages at the end of the tenancy, if there are any, from the animal, but you don't get to charge anything extra or on top of your security deposit. The service animals, if the person or the tenant approaches the landlord, whether it's in the beginning of the tenancy or 6 months in or whenever, and says, as an accommodation, I need a service animal. So the landlord has very limited sort of inquiry in this matter. They can, for example, they can say, I need more information, but the landlord cannot ask about the disability. So you don't get to say, well, what do you suffer from? That's out. And the tenant can provide something in writing from a doctor, but not necessarily a doctor, that says something to the effect of, this animal is helpful to my disability. And that really has to be enough for the landlord. So somebody, for example, could be suffering from anxiety, and you may not see that when you meet or interface with this tenant, but they may find comfort with a cat that helps to treat that disability. And so because of those reasons and the sensitive nature of it, can't ask much in the way of the cause or the need. But again, you can look to what's reasonable. If they want to have a horse in their living room, that's not reasonable. There's nothing that's going to treat, so you're okay to restrict that. But short of that, it doesn't have to be a dog or even a cat, but if the animal can treat or bring them comfort with respect to their disability, they get to have it, and you as a landlord don't get to turn them away. So this is critical because the punishment for violating these restrictions, or for example for not allowing a service animal, are severe. The landlord really can be punished, and it doesn't take much for the tenant to contact HUD, who has some authority in this area, as well as other housing agencies. There are civil rights acts that come into play. There's also the ADA, American Disabilities Act, that comes into play as well, and these have some teeth to them. So you've got to be very careful as a landlord. You certainly don't want to spend a bunch of money on legal fees. The whole point is to make money, not spend more than you need. So the pets are one thing, service animals are another, and as a landlord, you've got to be very sensitive to the difference and what the rights are and ability is for a landlord. So I would encourage anybody to seek legal counsel. I'm an attorney, but I'm not yours. So when you're faced with this request from a tenant, it's a good idea to look into it and get the answers that you need for your unique situation. Thanks for listening.